The Supreme Court, it's easy to just accept its power as a given, this ultimate authority to shape American governance. But it really makes you wonder, how did that become the reality? What's the origin story of that kind of influence?
Right. It feels so established now.
Exactly. Today on the Deep Dive, we're going right to the source, the 1803 case that essentially wrote the playbook, Marbury v. Madison.
That's right. We're plunging into this foundational decision. On the surface, it seems like a relatively minor dispute. A justice of the peace appointment for a guy named William Marbury. His commission was signed, sealed, but never delivered.
The delivery. That was the sticking point.
Leading to a lawsuit against the Secretary of State, James Madison, to force that delivery.
Okay, so Marbury's thinking, I got the job, the paperwork's there, just needs that final stamp, the delivery. But the new Jefferson administration basically said, nope.
Hold on there.
And that brings us to what we want to really understand today. It's not just about the he said, she said of this one case, but how Marbury v. Madison established this, well, rather extraordinary power of judicial review.
Exactly. And to see how deeply this idea is embedded in our legal system, we're going to look at how a similar line of reasoning, the core principle established in Marbury, has played out in other pivotal Supreme Court decisions.
Which ones are we looking at?
We'll be examining Dred Scott v. Sanford, United States v. Lopez, and United States v. Nixon. Our aim isn't just to retell the stories of these cases, but to really dissect the underlying logic and see the common thread that connects them back to Marbury.
Got it. So let's rewind and set the scene for Marbury v. Madison. This happened during a real sea change in American politics, didn't it? The transition from John Adams to Thomas Jefferson. What was the atmosphere like?
Oh, it was a period of intense political polarization. The final hours of his presidency in 1801, John Adams, who was a Federalist, made a flurry of judicial appointments.
The midnight judges.
Right, the midnight judges. It was a clear attempt to ensure his party maintained some influence within the judiciary as the incoming Democratic Republicans under Jefferson took control of the executive and legislative branches. It was pretty tactical.
And a central figure in this whole drama is John Marshall, who had a pretty unique foot in both camps, so to speak. How did that play out?
Well, what's fascinating here is Marshall's rather unprecedented position. He was the outgoing Secretary of State under Adams, so he was actually responsible for finalizing and delivering these very judicial appointments.
Okay, so he's the guy supposed to handle the paperwork.
Yes, but at the same time, he was also the incoming Chief Justice of the Supreme Court, the very court that would ultimately hear Marbury's case.
Wow, talk about a potential conflict of interest, although...
Although it wasn't viewed quite the same way back then, yeah. Different standards, perhaps.
You can see how that might raise a few eyebrows today. And as the clock ticked down on the Adams administration, it seems things got a little chaotic with these appointments, right? A number of commissions didn't actually get delivered.
Exactly. 17 judicial commissions, including William Marbury's, were signed but never officially delivered before Jefferson took office. Marshall, as the outgoing Secretary of State, seems to have assumed that his successor would simply see to their delivery as a matter of, routine.
Which, as we know, didn't happen. Jefferson had other plans.
Indeed. Once in office, Jefferson instructed his new Secretary of State, James Madison, to withhold delivery of some of these remaining commissions. Jefferson was understandably not keen on seating a bunch of last-minute Federalist appointees.
Makes sense from his political perspective.
And the crucial legal point here is that these individuals couldn't legally assume their judicial roles without having their official commissions physically in hand. No paper, no job, basically.
So, feeling that he had a legitimate appointment, Marbury takes legal action. What exactly was he asking the Supreme Court to do? What kind of legal tool was he using?
Marbury sought a writ of mandamus from the Supreme Court directed to James Madison. Now, a writ of mandamus is essentially a court order compelling a public official to perform a specific duty that they are legally obligated to do.
Like delivering a commission.
Right. In Marbury's case, he wanted the Supreme Court to order Madison to hand over his commission. He believed the law was on his side and that this was a straightforward ministerial act Madison was refusing to perform. Just, hand it over.
But this is where Chief Justice Marshall makes this incredibly shrewd move. Instead of just deciding whether Madison should deliver the commission, he steps back and asks a more fundamental question about the court's own power. What was that key question he posed?
The brilliance of Marshall's strategy, it lies in the question he framed. Did the Supreme Court even have the constitutional authority to issue this writ of mandamus in this particular type of case.
Jurisdiction.
Exactly. Instead of directly confronting the executive branch, which, let's face it, could have led to the court being ignored and its authority weakened.
Which was a real possibility back then.
A very real possibility. Marshall focused on defining the scope of the judiciary's power itself.
So to answer that, he had to dig into the foundational document, the Constitution itself. Where did he look specifically?
He turned to Article 3, Section 2 of the Constitution. This section lays out the jurisdiction of the Supreme Court, the kinds of cases it's allowed to hear. It draws a distinction between cases of original jurisdiction, meaning those that can start directly in the Supreme Court.
Like disputes between states.
Right, or cases involving ambassadors, and cases of appellate jurisdiction, which come to the court on appeal from lower courts. The Constitution specifically lists the types of cases that fall into the Supreme Court's original jurisdiction.
And this brings us to the Judiciary Act of 1789, which seems to throw a wrench in the works. What did that act say?
Well, the Judiciary Act of 1789, passed by Congress, included a provision that appeared to grant the Supreme Court the power to issue writs of mandamus to federal officials as a matter of its original jurisdiction.
So Congress seemed to be giving the court a power the Constitution didn't explicitly list under original jurisdiction.
That's exactly the conflict. This provision in the Judiciary Act is the basis of Marbury's legal argument. He was going directly to the Supreme Court asking them to order Madison based on that act.
Okay, so we have the Constitution laying out specific categories for the Supreme Court's original jurisdiction, and then this act of Congress seems to expand that list to include cases like Marbury's. What was the court's ultimate conclusion? How did they resolve this apparent conflict?
The court's decision, penned by Chief Justice Marshall, was a masterful piece of legal reasoning. They stated that while Marbury was indeed entitled to his commission.
So they agreed he should have gotten the job.
They did. The Supreme Court did not have the constitutional authority to issue the writ of mandamus in this case as a matter of original jurisdiction. They concluded that the provision in the Judiciary Act of 1789 that granted the court this power was in direct conflict with the limitations on the Supreme Court's original jurisdiction as clearly defined in Article 3 of the Constitution.
So the act of Congress contradicted the Constitution.
Correct. Therefore, that particular provision of the Judiciary Act was unconstitutional.
So Marbury doesn't get his commission through this lawsuit, but in the process, something monumental happens: the establishment of judicial review. Can you explain how this decision achieves that?
Absolutely. By declaring a portion of the Judiciary Act unconstitutional, the court asserted a fundamental principle. The Constitution is the supreme law of the land.
The ultimate rule book.
Exactly. And if any other law, even one passed by Congress, contradicts the Constitution, then the Constitution must prevail and the conflicting law is invalid. Crucially, the court also declared that it is the role of the judiciary to interpret the Constitution and to determine when such a conflict exists.
And that's where the famous quote comes in.
That's it. As Marshall famously wrote, it is emphatically the province and duty of the judicial department to say what the law is.
That single sentence carries so much weight. So even though Marbury lost his immediate battle, this case established the Supreme Court as the ultimate referee on constitutional matters, elevating the judicial branch to a co-equal status with the executive and legislative branches. It's the foundation upon which so much of our legal system rests.
Precisely. And this principle of judicial review, established in Marbury v. Madison, is the key thread we see running through other significant Supreme Court cases. Think about Dred Scott v. Sanford in 1857.
Okay, big jump in time, very different subject.
Very different subject matter, yes. On the surface, it's about slavery, a completely different issue. But what's the connection to Marbury?
Well, Dred Scott dealt with the constitutionality of the Missouri Compromise, right? Congress had passed a law,
Exactly.
and the Supreme Court ultimately declared it unconstitutional.
Precisely. The court in Dred Scott, just like in Marbury, examined an act of Congress, the Missouri Compromise, which sought to regulate slavery in the territories, and determined that it conflicted with the Constitution, specifically the Fifth Amendment's protection of property rights, as they interpreted it.
So they used the same power as in Marbury.
They asserted its power to strike down a law passed by the legislature, echoing the very principle established in Marbury. The tragic irony, of course, is the morally reprehensible outcome of the Dred Scott decision, but the method the court employed judicial review is directly traceable back to Marbury v. Madison.
Wow.
They both involve the court saying, This law conflicts with the Constitution and therefore cannot stand.
It's a stark reminder that the tool of judicial review can be used in service of very different, and in the case of Dred Scott, deeply unjust ends. Now, let's fast forward to United States v. Lopez in 1995. What's the link there to Marbury? That case dealt with a federal law about guns in school zones?
Right. Congress passed the Gun-Free School Zones Act under its Commerce Clause power, arguing that guns in schools could affect interstate commerce. In Lopez, the Supreme Court again reviewed an act of Congress and asked whether it was constitutional, whether Congress had exceeded its enumerated powers under the Constitution.
So again, checking Congress's homework against the Constitution.
Basically, yeah, and the court ultimately said that Congress had overstepped its authority in that instance.
They did. How so?
Precisely. The court held that the Gun-Free School Zones Act was unconstitutional because, in their view, the link between possessing a gun in a school zone and interstate commerce was too tenuous, too indirect. They limited the scope of Congress's Commerce Clause power.
Okay, so what's common with Marbury here?
Well, the common thread is that the court is once again acting as the interpreter of the Constitution, defining the boundaries of power in this case, federal power under the Commerce Clause, and striking down a federal law that they deem to be outside those boundaries. Just as in Marbury, they looked at the Constitution and said, this act exceeds the permissible limits outlined in this document.
So in both Marbury and Lopez, the court is essentially saying the Constitution sets limits, and it's our job to make sure everyone stays within those lines, whether it's Congress passing a law about judicial procedures or a law about gun control near schools.
Exactly. The court principle is the same. The Constitution is supreme, and the judiciary has the authority to say when another branch of government has acted outside of its constitutional limits.
Okay. Finally, let's consider United States v. Nixon in 1974, during the height of the Watergate scandal. That seems a bit different because it involves the president, not an act of Congress. Where does Marbury fit into that picture?
That's a great point. In United States v. Nixon, the court was asked to rule on the scope of executive privilege. The president's claim that he could withhold certain information, specifically those Oval Office tapes.
Right, the famous tapes.
The court had to determine whether this presidential power was absolute or if it had limits, especially when faced with a subpoena in a criminal investigation. And in making that determination, the court explicitly invoked Marbury v. Madison.
They actually cited Marbury in a case about presidential power. How did that connection work? I wouldn't have immediately thought of that.
Yeah, they did. The court in Nixon directly quoted Marshall's famous line, "It is emphatically the province and duty of the judicial department to say what the law is." They used this to assert their authority to decide the constitutional question of whether executive privilege was absolute.
So they're saying it's our job to interpret the Constitution, even when it involves the president's powers.
Exactly. They reasoned that if the president could unilaterally decide what information to withhold, without any judicial oversight, especially in a criminal matter, it would undermine the very system of checks and balances established by the Constitution. It would clash with the judiciary's function. So, just as in Marbury, where the court asserted its power to interpret the Constitution and strike down an act of Congress.
In Nixon, they asserted their power to interpret the Constitution and define the limits of presidential power.
Precisely. In relation to the judiciary's role in administering justice, drawing directly on the fundamental principle established way back in Marbury.
So even when dealing with the executive branch, the court relied on the foundational principle established in Marbury. The judiciary is the ultimate interpreter of the Constitution and its provisions, including those that define the powers of the other branches.
Precisely. In all four of these seemingly disparate cases, Marbury dealing with a judicial appointment, Dred Scott with slavery and congressional power, Lopez with gun control and the Commerce Clause, and Nixon with presidential power, the Supreme Court consistently exercised the power of judicial review.
That's the common thread.
That's the thread. They examined the actions of either the legislative or executive branch and determined whether those actions were consistent with the Constitution, all stemming from the precedent established in Marbury v. Madison.
It's remarkable how this single case from over 2 centuries ago continues to shape our understanding of the separation of powers and the role of the judiciary in American government. It really highlights the enduring significance of Marbury v. Madison. It wasn't just about one guy's job.
Absolutely not. While the specific issues and outcomes of these cases varied dramatically, some celebrated, some condemned the underlying principle of the Supreme Court as the ultimate interpreter of the Constitution remained constant.
It makes you really consider the long shadow cast by that 1803 decision. Think about it. What are the implications today of having a non elected body with the final say on what is constitutional? How does this power of judicial review continue to influence the ongoing debates about the balance of power in our government and its impact on our lives? It's definitely something to think about long after this deep dive is over.